The Village of Stratton had an ordinance meant to discourage uninvited solicitation on private property in the village. The prospective canvasser was required to obtain a solicitation permit from the mayor's office, the permit being free of cost and available after filling out an application form. The Watchtower Bible and Tract Society of New York filed a suit against the Village of Stratton, seeking an injunctive relief against the ordinance.
The argument being that it violated the constitutional guarantees to freedom to practice one's religion, free speech, and freedom of the press. The federal district court decided that the ordinance was constitutional and that the same was affirmed by the federal court of appeals. The Village of Stratton appealed.
Your Honor, if the court may acknowledge a municipal ordinance which requires a prior registration and permit before door-to-door canvassing for a political cause is against the First Amendment. The ordinance in question covers a wide range of speech, which gives room for concern. It infringes on the First Amendment guarantee as to freedom of religion, of speech, and of the press, but even more, it violates the basic concept of what a free society is. That is, in a matter of routine public speech, a citizen need not expect that he must first inform the government and then take a permit to speak to his neighbors. The issue is not whether the permit is promptly and freely issued to all seekers, but that such an activity constituting one aspect of free speech should seek to be regulated by the government. This violates heritage and tradition of the United States Constitution and nation. Even spontaneous acts like urging a neighbor to vote for or against some candidate at the neighbor's door, even if just across the street, would bring a charge of unlawful activity against one.
This ordinance is neutral as to whom it affects and place no restriction on the activity of any door-to-door activist. The only object is to regulate the manner in which one does so. It would surely result in fewer persons doing this. Since the permit is not subject to the discretion of any officials or governing body, it does not violate any basic freedoms.
Conclusion of the Supreme Court noted in this decision is that whether or not a person has a permit, the disturbance caused is the same for the subject of the activity. The official record did not show any evidence of criminal activity associated with this type of visiting, which would justify the requiring of a permit beforehand.
For this court is whether the public burning of an American flag which occurred as part of a demonstration with political overtones is entitled to the First Amendment protection. The flag burning in this case occurred during the 1984 Republican National Convention in Dallas, Texas. The flag was burning in front of Dallas City Hall as the accumulation of a demonstration march throughout downtown Dallas in the midst of a crowd of demonstrators and onlookers. The flag burner, who was identified as Mr. Johnson, was convicted under a Texas salute which prohibits desecration of the national flag. His punishment was assessed at 1 year in the county jail plus a $2,000 fine. The conviction was affirmed on direct appeal by Intermediate Courts of Appeal. Mr. Johnson then files petition for discretionary reviews to the Texas Court of Criminal Appeals. That is the highest court in the state of Texas which hears criminal cases. The court granted his petition, reversed his conviction, and ordered the information dismissed. The Court of Criminal Appeals held that Texas salute was unconstitutional as applied to Mr. Johnson, since he was a political protester. Judge Campbell on that court found that flag burning constituted symbolic speech within the tests initiated by this court in Spence v. Washington. That court also found that Texas asserted interest in regulating the act of flag burning with insufficient to outweigh a protester's First Amendment right to expression. For purpose of this argument today, and with the court indulgence, the state will assume the symbolic speech standard and proceed directly to the question of Texas' compelling interest in regulating this type of conduct. Throughout the course of the appellate history in the case, Texas advanced two compelling state interests. One is the prevention of the flag as a symbol of nationhood and national unity. The second, the prevention of breach of the peace.
The statute in question today is not the legality of burning the flag, but instead the government's ability to regulate the use and establish proper etiquette of the flag. Can you say you can't force them to salute the flag or pledge allegiance to the flag, but can you then say we can force them to not show other means of disrespect for the flag, other means of protest over the flag,
by saying you can't burn the flag, I think they're the same in all due deference. The statute itself is not limited to just the flag. The portion that is in question here is limited to the flag, but it has made a judgment that certain items are entitled to more protection. You can honor if you like, but you cannot dishonor. It is a sign of disrespect for the country.
In conclusion, the court has ruled 8-1 in favor of Johnson. It is unconstitutional to prosecute any person for a nonviolent act of speech. Speech is therefore not limited to the extent of either mouth or script, and extends as far as acts of speech. The Supreme Court agrees to hear the case to determine the procedural rights of a juvenile defendant in delinquency proceedings where there is a possibility of incarceration.
Paul Galt was a 15-year-old accused of making an obscene telephone call to a neighbor, Mrs. Cook, on June 8, 1964. After Ms. Cook filed the complaint, Galt and a friend, Ronald Lewis, were arrested and taken to the Children's Detention Home. Galt was on probation when he was arrested, after being in company of another boy who had stolen a wallet from a woman's purse. At the time of the arrest related to the phone call, Galt's parents were at work, and the arresting officer left no notice for them and did not make an effort to inform them of their son's arrest. When Galt's mother did not find Galt at home, she sent his older brother looking for him. They eventually learned of Galt's arrest from the family of Ronald Lewis. When Miss Galt arrived at the detention home, she was told that a hearing was scheduled in juvenile court the following day. The arresting officer filed a petition with the court on the same day of Galt's initial court hearing. The petition was not served on Galt or his parents. In fact, they did not see the petition until more than 2 months later, on August 17, 1964, the day of Gerald's habeas corpus hearing. The June 9th hearing was informal. Not only was Mrs. Galt not present, but no transcript or recording was made, and no one was sworn in prior to testifying. Galt was questioned by the judge, and there are conflicting accounts as to what, if anything, Galt admitted to. He was detained for another 2 or 3 days before being released. When Galt was released, his parents were notified that another hearing was scheduled for June 15, 1964. Mrs. Cook was not present for the June 15th hearing either, despite Miss Galt's request that she be there so she could see which boy had done the talking, their dirty talking over the phone. Again, no record was made, and there were conflicting accounts regarding any admissions by Galt. At this hearing, the probation officer filed a report listing the charge as lewd phone calls. As an adult charged with the same crime, they would have received a maximum sentence of a $50 fine and 2 months in jail. The report was not disclosed to Galt or his parents. At the conclusion of the hearing, the judge committed Galt to juvenile detention for 6 years until he turned 21.
The Supreme Court noted in the decision that Mr. Galt was overly punished for his crime, and people under 18 now have the same right as adults when it comes to the Bill of Rights and the 14th and 6th Amendments.